you for joining this next installment of Axon Health's clinical and professional webinar. Something a little different today. Normally we cover clinical topics, and today we're going to talk a little about the ADA, or the Americans with Disabilities Act. We're very happy to have Margaret Edwards with us here today. I heard Margaret talk at a conference a couple of months ago, and a really good presentation that I thought would be valuable to all of you on the phone here today. So again, very, very happy to have Margaret with us. Margaret started her law career with a Juris Doctorate from Northwestern University. And since that time, she has litigated hundreds of cases in both state and federal courts. Margaret also advises and represents employers in a broad variety of employment and labor matters, focusing on the defense of discrimination, retaliation, and wrongful discharge claims, just to name a few. Additionally, Margaret routinely advises employers on legal compliance, including international employment compliance, litigation prevention measures, and business restructuring. She also, interestingly enough, provides training to managers and human resource professionals on employment law subjects. She works with both the Littler Learning Group and ELT Incorporated to develop new training programs. Margaret has written more than 36 articles on employment law subjects, such as how to avoid retaliation claims, preventing workplace violence, email and internet usage policies, and appropriate enough for our topic today, the American with Disabilities Act. She is also a very active lecturer, with lecturing at places such as University of California, Berkeley School of Law, Stanford University School of Law, and Golden Gate University School of Law. So with that wonderful background, we're very excited to have Margaret here with us today. And good morning, Margaret, and thank you so much for joining us.
Well, thank you very much, and I'm delighted to be here, and I'm delighted to talk about one of my favorite subjects, which is the Americans with Disabilities Act. I'm going to start with government enforcement, because government enforcement is really a pretty key aspect of the ADA. Right now, the Equal Employment Opportunity Commission, which is the key enforcement arm for the federal government, as well as private litigation, is not fully staffed. One of the members quit, and right now we have a new person nominated as of last month, and we have a Democrat majority on that particular body. The EEOC has set some strategic enforcement priorities, and the Americans with Disabilities Act is featuring pretty prominently in those strategic enforcement priorities because they, of course, want to protect some of the more vulnerable workers, and they have specifically announced that they want to address emerging issues such as the way the ADA Amendments Act, that's that ADAAA, and pregnancy overlap. And they have been looking at filing strategic lawsuits to address systemic discrimination. They also are issuing some guidance for employers, although it is a bit a little too little and a little too late sometimes. There is supposed to be a lot more guidance coming from the EEOC on what to do with wellness programs, because there are some wellness regulations that exist under GINA and under the Affordable Care Act, but we don't really have the EEOC's voice on how to handle wellness program features under the Americans with Disabilities Act, which does restrict medical inquiries, and that's really the rub here. As a matter of fact, the EEOC has been particularly difficult to read in this area because it has filed 2 lawsuits during 2014 against employers running wellness programs, claiming that the features of those programs that essentially created a much higher cost for medical care or medical coverage for employees who refuse to undergo either a physical or answer the questions of a health questionnaire, rendered their participation involuntary. So they are probably going to file more lawsuits, and we're hoping for some more helpful types of regulations or guidance from the EEOC so that employers know what to do. They did issue some other guidance documents in the last 12 months, and of these listed on the slide, the most important by far is the guidance that they issued in July 2014 on pregnancy discrimination and related issues. So all of you who have to deal with pregnant employees and employees claiming that they're disabled because of pregnancy, this document really is a must-read. It's about 35 pages long, and it is intended to be the EEOC's sort of definitive view on how to handle pregnancy discrimination and related issues. The EEOC has been extremely busy. It's filed, received a very large number of charges in the last fiscal year. It has collected a record amount of money for victims of discrimination. It's filed a lot of different kinds of lawsuits. Systemic suits are pattern and practice cases. And as you can see, the ADA is one of its most popular types of claims. The highest is good old-fashioned discrimination claims under Title VII of the Civil Rights Act of 1964. The charges under the ADA have been mounting for the last several years. You'll see a big uptick in the numbers in 2009. That's because that was the year that the ADA was amended by the ADA Amendments Act. Those amendments were effective at January 1, 2009, and those amendments greatly made it easier for people to file claims of disability discrimination. The top types of ADA charges that are showing up are discharge, reasonable accommodation, terms and conditions of employment, which includes a lot of different stuff, even holiday parties, harassment, discipline, hiring, assignment, constructive discharge, suspension, intimidation, promotion, and demotion. And there are certain impairments that are the most common in the EEOC charges that are filed. And you may notice that orthopedic and essentially mental impairments feature fairly large here. And those are important areas to keep an eye on. And the value of impairments is sometimes, in terms of how much it costs to settle a case, is sometimes not the same as how many of the charges are filed. So as you can see, if you rank them by impairment basis, by how much money was spent resolving charges and different kinds of lawsuits with the EEOC, these are the top dollar types of impairments. The definition of disability was greatly expanded by the ADA Amendments Act, and the purpose of Congress was stated to actually restore the original intention of the Act when it was passed in 1990. And the net result of that has been to focus the fight in lawsuits under the ADA away from whether or not the individual meets the definition of an individual with a disability, in other words, whether they have a covered disability, to whether or not they were given the accommodations they should have been given, are they able to perform the essential functions of the job, are they in fact a qualified individual with a disability. And this change in focus really has started showing up during the last couple of years. There's always a time lag because litigation is not very fast. The results now, though, are beginning to show, because fully a vast majority of the cases, more than 85% at the appellate level, that's the circuit court level, and 75% at the district court level, that's the trial court level, are finding that the plaintiff was in fact disabled. So now the focus is really more on qualifications and essential job functions. But another thing that the ADA Amendments Act did was also expand the definition of major life activities that could be impaired. And as a consequence, if you look at the list on the slide, you'll see that virtually every major life activity that you can think of is indeed now covered in some function or in some way by the definition of disability. The ADA Amendments Act also now said that the major life activities includes major bodily functions, and they endeavored to list all the major bodily functions. One of the results of this is that in 2014, one of the first cases to define a severe obesity as a disability came down in April 2014. So we now we're seeing a definitional expansion take hold. There is no definitive list of covered disabilities, although there are certain disabilities that are mentioned in the ADA Amendments Act as essentially presumed to be disabilities that would be covered by the Act. These are very often things that are either difficult to see or episodic. Pregnancy is not a disability if it is a normal pregnancy, but complications of pregnancy may be disabilities even though they are temporary. And the EEOC's new guidance is very explicit on this point. A number of states have even more protective laws, including my home state of California, which is very protective with respect to pregnancy disability and defines it very broadly indeed. Temporary impairments can be a disability. This has been a source of a lot of questions over the years about whether or not it is something that, how temporary is temporary, and are temporary disabilities really supposed to be within the ADA? The ADA Amendments Act punted on this issue. It didn't specifically address it, but the EEOC went ahead and said that it would consider temporary disabilities covered if they were sufficiently severe. This year, earlier in the year, we had the Summers versus Altarum Institute case where a man had a pretty awful accident trying to get on and off a commuter train, tore a lot of things and broke a lot of things, and as a consequence, he was not allowed to return to work, even though he tried valiantly to return to work. But the employer didn't seem to want to let him come to work sort of part-time and get back into the swing of things, and instead just replaced him. He filed a lawsuit and lost on the trial court level, but he won on the appellate level. And this is the first appellate decision on this issue. The court found that the impairment was indeed severe, that without the surgeries, Mr. Summers might not have been able to walk for more than a year, and that under the ADA Amendments Act, it had to disregard that Summers could use a wheelchair, which is a mitigating measure, and the ADA Amendments Act says we disregard those to determine whether or not there's a disability. And it found that a reference in the ADA Amendments Act to a 6-month limitation for minor impairments only was for those that were regarded as disabilities. So it took a very narrow view of the 6 months limitation and adopted the EEOC's interpretation that temporary impairments would be covered. So we should assume, I think, that any kind of sufficiently severe temporary impairment is a covered disability now. So what is a qualified person with a disability? How do we know if a person is qualified? Well, the first focus usually is whether or not they can perform the essential functions of the job, which means that the next question that everyone has to argue about is what functions of the job are essential and what functions are not. An employer can't just simply label something as an essential function and expect to have that label deferred to. It really has to be a function for which the job was designed, really central to the purpose of the job. It has to be something usually that takes a fair amount of time, although not necessarily. And it has to be something that perhaps is not particularly easy to delegate to someone else. So we had a case this past year, the Knutson versus Schwann's Home Service, which was an interesting take on this because here was a person who was a manager of a delivery service, and he was managing essentially a bunch of truckers who were supposed to be Department of Transportation qualified, and he had an eye injury, which meant that he could no longer meet the Department of Transportation qualifications himself to drive. And he very seldom had to drive in his job. But the employer considered it to be an essential function, and the court agreed. So one of the things that is very important is is coordinating communications properly when people are going to go on leave and when the leave may involve a workers' compensation claim. It's important to make sure that the leaves are running concurrently, which means that whoever is doing the coordination has to understand well how the leave laws work and how to do that kind of stacking of leave. So FMLA should be running, for example, concurrently with the workers' compensation leave. The different leaves also have different reinstatement rights, although generally they all carry full reinstatement rights. And then, of course, it's important to remember that any kind of workers' compensation leave period counts as months of service towards FMLA. One area in which there is a great deal of litigation is about the difference between providing light duty versus waiving essential functions. And light duty often does involve waiving essential functions, and that creates substantial confusion when we get into what is a reasonable accommodation and what is not. We'll probably mention that in a moment in more detail. Another thing to make sure that people understand is that there is a limit on how much medical information they can request, and the EEOC has become very active in that area, and that different definitions of disability apply depending on what kinds of statutes you may be looking at. So state workers' compensation laws don't use the same definition of disability as the ADA. Nor does the Social Security Act, nor do private definitions of disability under things like long-term disability or short-term disability plans. So it's really important to keep that in mind. Also, when a person is permanent and stationary under workers' comp, that does not give the employer permission to say goodbye to the employer. It may be the point at which a perhaps overdue discussion should start about reasonable accommodations to allow a person to return to work. So there are a number of different considerations about returning people to work, and one of the things to really focus on is the communications and to make sure that employees know that they may be required to undergo some kind of fitness for duty to return to work. It depends on the process. Ordinarily, fitness for duty is not presumed necessary to return to work unless the employer makes it clear at the front end of the leave that that may be the case. But someone has to be managing this process and to make sure that they do so in a way that is sensitive to both the leave laws and the requirements of the ADA. There's been a lot of confusion between the not terribly nice seam between the ADA and the Family Medical Leave Act, and it just gets a little bit harder each year. So one of the things that a number of employers have been doing is putting people on FMLA leave even if the employee didn't necessarily request FMLA leave because they wanted to use it up. And this new case that came down this year, Escriba versus Foster Poultry Farms, now raises a question as to whether or not employers can indeed do that without running the risk of engaging in FMLA interference, which is prohibited. The Kleinzer case illustrates where FMLA really is different from ADA, because when a person is on FMLA leave, they're on leave, and they cannot be on FMLA leave and compel the employer to put them on light duty and allow them to take an intermittent leave instead of a continuous leave, according to the Kleinzer case. Then it's also not a violation of the ADA to deduct time off from an FMLA balance. That would be a nasty turn of events if it were. And it is also not FMLA interference when a person was given a 15-month workers' comp leave to forget to charge it against FMLA because they, in fact, got the benefit of the leave. Medical documentation is restricted, and it gets more restricted all the time. The EEOC issued a letter earlier this year explaining that demanding too much detail during the reasonable accommodation process is a violation of the medical inquiry rules that are embedded in the ADA. So really, one can only ask for what one absolutely needs from medical personnel, nothing more. In the Roman Oliveras case, it was kind of an interesting case because the employer evidently was not in a hurry to restore this particular person to work after he'd gone on leave because he had schizophrenia, and they kept forcing him to undergo repeated medical evaluations, presumably hoping that someone was going to evaluate him and say, oh no, he shouldn't be working. And that pattern of behavior was found to violate the ADA. And then a very interesting case, the Conroy case, says that you can't require essentially diagnoses to be provided to the employer as a return to work condition. And the difference between providing medical documentation of the need for an accommodation or the need for a leave and providing medical diagnoses is one that continues to evolve, because most people that want to know, well, what's wrong with him? And that very often is asking for information that the EEOC and increasing number of states take the position really doesn't have to be required. So just to refresh everybody's memory here, the EEOC has always had very tough rules in the ADA about when medical inquiries may be made. So before a job offer is made, nothing can be asked for. After a job offer is made, very limited Job-related and consistent with business necessity information can be requested, including a medical exam, but only if it is done for all persons within a particular classification of jobs. So you can't just pick on somebody who discloses a disability and have them undergo a medical exam. And then after employment begins, one can only ask for medical information when it's both job-related and consistent with business necessity. And those terms have, a very specific meaning, and they're getting the concept of job-relatedness and the concept of business necessity get constantly worked out through case law, and they're pretty narrow. So what is a restricted inquiry or exam? Well, just about anything that asks people to disclose a disability or to disclose a disability in their family, and any kind of medical examination of any sort whatsoever could qualify as a restricted exam. There are certain things that are not restricted by the ADA, and there have been quite a few cases that try to distinguish between these unrestricted questions and restricted medical inquiries. So it is all right to do testing for illegal drug use. It is all right to do job-related physical agility tests, but they really have to be very close to the physical agility required by the actual job. So if someone had to climb a ladder, for example, they could be asked to climb a ladder. And then there are certain kinds of other things that are given. The old-fashioned version would be a typing test to evaluate the ability to perform actual job functions. And then certain kinds of personality tests are not restricted by the ADA because they're not actually clinical tests. They're not things like the MMPI, which is restricted under the ADA. The ADA this year also came out with a rather interesting letter saying that an employer in a nuclear power plant that had a policy that workers who had been determined to be alcoholic must abstain totally from drinking. And the EEOC said that that particular policy was not consistent with business necessity and did not meet the direct threat standard. Direct threat is a affirmative defense that employers have that they don't use very often because it's very difficult to prove to a claim of disability discrimination. So what are some of the things that go beyond the limits of reasonable accommodation? Because almost anything, any kind of job change or adjustment could be a reasonable accommodation. But every once in a while there'll be a case that comes down that shows us where the outer limits are. So the Wiesner case showed us that having HR involved in every counseling discussion that an employee unilaterally considered threatening was not reasonable. Providing an assistant to the employee who had a severe physical disability to help the employee go to the restroom was not reasonable. Changes made to accommodate the employee's long commute. Now the long commute was, the employee's choice, so to speak, and that was really not something that had to be accommodated. And then most recently this year, the court held that for a person in a job of a janitor to say that they had to have no exposure to cleaning solutions was impossible for all practical purposes for the employer to perform. As I mentioned, one of the things that is really critical in defending a disability discrimination claim is whether or not the employee can perform essential job functions. So who proves whether or not a function is essential? Essentially, it's up to the employer to prove that a function is essential. This didn't used to be a big battleground between employers and employees, but it is now since the ADA Amendments Act. So one of the cases that came down, the Sampson versus FedEx case, seemed to indicate that a job function was not essential if it was only performed less than 4 hours per year. And that may be the case in that particular job. It may not be the case in all jobs, because one of the EEOC's very first examples when the ADA was first adopted in 1990 was that the ability to climb a ladder on a hook and ladder and rescue an adult from a burning apartment building doesn't happen every year to a fireman, but it is something that he must be able to do. And so there are still rare functions that could be essential job functions. The Robert versus Brown County Board of Commissioners case clarified a point which is important, which is just because an employer may provide light duty and waive an essential function for a fairly extended period of time, that's not making an admission that the function is not essential. And then a very interesting case, and this is not the only one, there have been a number of them in the healthcare field, saying that working on call and being able to work an 8-hour shift is an essential function for a nurse. In this particular case, the nurse had taken a leave for atrial fibrillation, then had a stroke and had aphasia, and wanted to return to work working very limited hours and never take on call. Is attendance an essential function? Well, you would think yes, but the answer is really more sort of. And the reason that the answer is sort of is because there has been very aggressive enforcement by the EEOC that, you know, providing a leave of absence is a reasonable accommodation even if an extended leave has already been provided under the FMLA or perhaps under workers' comp laws. And no matter what an employer's policy may say, the answer is that you have to look at it on a case-by-case basis. So there was an important case against UPS that was filed this year because UPS had a policy that after a 12-month absence, you were deemed not qualified, or basically you're going to be terminated. And the EEOC said that this particular policy tended to screen out people with tended to screen out people with disabilities. So this is an ongoing case, but it's not the only ongoing case against policies of that kind. The EEOC has sued several other people, or I should say several other companies, for similar policies, and some of these settlements have been very large, such as the $20 million settlement against Verizon Communications, which had a no-fault attendance program. So this is something that the EEOC is doing, and different regions of the regional offices of the EEOC have adopted this as a major focus. Now, is the EEOC right in these cases? Well, not all courts seem to agree, and in one case that came down in May of this year, Huang versus Kansas State University, the court found that a 6-month leave of absence was not a reasonable accommodation under the Rehabilitation Act. The Rehabilitation Act is a federal statute that was a predecessor of the ADA, and it has very similar provisions. It just happens to apply to federal employers and recipients of federal funds. And they came up with this notable quote that it's difficult to conceive how an employee's absence for 6 months, an absence in which she could not work from home, part-time, or in any way, any place, could be consistent with discharging the essential functions of most any job in the national economy today. So employers are happy with this particular decision, but it's very much a question right now whether it's going to have influence outside the 10th Circuit. However, many cases do acknowledge that attendance is an essential function, and this case from 2013, Murphy versus Sampson Resources, is an illustration in a more office environment. This was an accountant who had terrible migraines, and the migraines came on without warning, as migraines do, and it was not possible to deal with the deadlines that this accounting person had to meet and have a completely flexible schedule and get the work done. And so as a consequence, the attendance was found to be, predictable attendance was found to be an essential job function in that case. But other cases show that this is very much a very specific circumstances, so it really depends on the particular job. In the Fuentes case, a quality control employee who missed 40 work days in a single year was found not qualified. But there are other cases that come out the other way. The Samper case is typical of some of the cases involving people in sensitive healthcare positions, where it found that a neonatal ICU nurse could not have unspecified, unplanned absences because they would compromise the quality of patient care. How about punctuality? Do we care? Well, of course, we care as employers, but and the EEOC has actually raised the question that only job duties, meaning the tasks that have to be performed, can be essential functions, not actually showing up on time to perform them. However, the McMillan case is an example of a small cluster of cases that have found that being on time to work can indeed be an essential job function. There are certain patterns that are of behavior that are very dangerous for employers, I should say. One is to have a policy of light duty only for on-the-job injuries. The EEOC has now explicitly said that if you offer light duty to a person with a disability for an on-the-job injury, you have to do the same for a pregnant woman. And the indication is that the EEOC wants employers to be blind to the cause of the disability in terms of the policy of light duty. It's also dangerous to have a policy that one can return to work only when one has a full release. That's a fully healed type policy that screens out people with a disability, and it avoids the duty that all employers have to engage in reasonable accommodation. So it's not acceptable. It's also very dangerous to allow the leave, but then go ahead and fill the job with a permanent replacement. Filling the job with a temporary replacement is fine, but a permanent replacement suggests that the individual has, in fact, for all practical purposes, been terminated, the one that was on leave, that is. Attendance policies with automatic termination triggers, we just talked about that. Those are getting EEOC attention. The EEOC also does not approve of employers essentially assuming that they know what is best for the employee and engaging in their own diagnoses and engaging in somewhat paternalistic practices that are supposed to protect the employee by forcing him on leave, for example, instead of letting him try to work through with reasonable accommodations. And then, of course, the biggest sin of all and the most common is not communicating with employees while they're on leave and just forgetting that they're even there. So how much leave is enough? There are no bright line rules or magic numbers, but there are a couple of concepts that are really key. One is that the whole point of providing additional leave to employees, and sometimes in many, many chunks, is that they have to be able to resume performance of the essential functions. So the duration of the leave is such that, it's supposed to be a way to ultimately return to work, not a way to just stay on leave for years on end. Employers really need to avoid binary thinking. It may not be a question of whether or not to put people on leave. There may be ways to modify schedules, telecommute, put people, use some devices, use technology, and employers ultimately get to choose the accommodation. They are supposed to listen to employee preferences, but they choose the one that is going to allow the person to perform essential functions. Indefinite leave is not a reasonable accommodation. And it's not a reasonable accommodation because it doesn't lead to performance of essential functions. It just means that a person is out on leave. One thing that's very difficult sometimes for employers to do is to prove that a leave is indefinite, because sometimes the employee asks for leave in 1 month chunks, and this goes on for rather a long period of time before it finally begins to look like it truly is indefinite. Because, people seldom say, oh, I need an indefinite leave. Is telecommuting a reasonable accommodation? Well, this has been a question that's been rolling around in the courts for several years, and most of the decisions before this year generally said that telecommuting could be, but probably wasn't, a reasonable accommodation in most jobs. And then we had the decision of the Sixth Circuit in EEOC versus Ford Motor, which really has language in it suggesting that in many jobs in the current economy, telecommuting may be a reasonable accommodation. Now, this particular decision has caused quite a hubbub, so rehearing has been requested. And who knows, maybe the Sixth Circuit, when it's the full Sixth Circuit, all the judges as opposed to just 3 of them, they may change their mind, but I don't think they will. But this particular case involved a person who really had a lot of customer contact, but most of the customer contact was by telephone, and she had irritable bowel syndrome, and her symptoms were getting worse and worse. And she tried, she had a telecommuting trial of flex time, and it just didn't work out very well from Ford's point of view. And she kept trying. She kept requesting telecommuting, and she pointed out that some other people had been allowed to do part-time telecommuting. But Ford decided that the position itself was not suited to telecommuting and offered her alternative accommodations. And she filed a charge, and she was terminated for poor performance. And when it got to court, it was found that she was qualified for her position, and that it was going to be Ford's burden to prove that physical presence was an essential function. That really there is a difference between the attendance cases, and attendance being an essential function, versus offering to attend remotely. So I think this case is going to be quite an interesting case to follow. So when an employer decides that it cannot provide any accommodations, that there aren't any accommodations, or that the only accommodations available are very, very difficult or very expensive, then it's going to be the employer's burden to prove undue hardship. And that standard is very high. So some of the factors that are looked at are the effects on other people who will cover the work, and whether or not there is a lowering of quality or productivity, if there are substantial overtime costs, if there's an impact on customer service, and so forth. The key here is that employers have to really engage in an in-depth analysis, and they have to be able to document that these costs or inconveniences are real. Because if they cannot do that, they will not be able to prove undue hardship. Now, what about providing those past accommodations? If you provided past accommodations as an employer, does that mean that you can't prove undue hardship? The answer is no, but it certainly does complicate the issue because, of course, having waived essential functions once, it's going to be argued that the functions were not indeed essential. So some of the things that really undermine undue hardship proof is if the accommodation has indeed been provided to other people. That's a very, very devastating fact for a defense. Or if the work, if the accommodation is a leave, the work is being successfully performed by temps or coworkers. Another thing that is a bad fact is if there's a termination right before a return to work date, because that looks retaliatory. And then if the person is terminated after not having been accommodated and the position is not timely posted and filled, that suggests that, well, I guess the position wasn't all that important after all. So what about reversing a termination decision? Is that a reasonable accommodation? There have been circumstances where the EEOC has argued, yes, it is not necessarily a reasonable accommodation. And these cases all turn on the strength of the record. So what was the termination based on? Was it based on legitimate business reasons, and how well are those documented? What was the relative timing of the notice of disability and any kind of notice of performance problems leading to the termination? And when was the decision really made? Was the decision to terminate made just after someone announced that they needed accommodations, or had that decision been made before that and just simply not yet announced? So sometimes email is rather critical in these cases. Another accommodation that has to be provided when other accommodations are not available is reassignment to a vacant position. And it's supposed to be the closest approximation to the position that the person used to have. One of the questions that's come up is, does the individual have to be the best qualified person in order to be reassigned? Or do they get a preference because of disability? The EEOC takes the position that the employees get the reassignment without having to compete for it and without having to be the best qualified. They do have to meet, the minimum basic qualifications such as education, experience, and so forth, but they don't necessarily have to be the best qualified. Now, the federal courts in the country are somewhat split on this. So certain circuit courts agree with the EEOC, and some of them are less sure. This issue came up in front of the U.S. Supreme Court a few years ago, but it declined to decide it. So what about medical marijuana? We're hearing about medical marijuana in the news these days. Everybody is thinking about it, and now that a number of states allow medical marijuana, or even not medical marijuana to some degree, does that mean that marijuana use has to be accommodated by employers under the ADA? No federal cases yet require this. And it may not happen right away because the ADA does not require an employer to accommodate illegal drug use. And the way that phrase is defined is to refer to federal drug laws, not state drug laws. And as everyone knows, federal law does not permit medical marijuana use. So until that changes, and maybe it will change at some point, the ADA is not likely to be requiring accommodations for medical marijuana use. Now that does not necessarily mean that that will be true in certain states. And one state, Nevada, does require accommodation at this point. So this is one to watch because it is evolving so very, very quickly at this point. And the last point I'd like to make is to not forget another federal statute that interacts with the Americans with Disabilities Act. And this is the Genetic Information Non-Discrimination Act, which severely restricts the collection of medical information because genetic information under GINA, as it's known as, includes family medical history information. And family medical history information, of course, is a basic part of a history and physical. It's very frequently requested on behalf of an employer if an employer sends someone off to an exam, but it cannot be requested now under GINA in many circumstances. And the employer needs to be extremely careful if it receives this information not to let it get into personnel files or anything of that kind. As a matter of fact, when an employer receives a subpoena for records of an employee, it has to be very careful not to disclose, even in response to a subpoena, any genetic information unless that information is specifically called for under the terms of the subpoena. So this is a tough law. It does have a safe harbor provision which should be used in all circumstances where the employer is sending off requests to healthcare providers for information in connection with, say, a reasonable accommodation request or a fitness for duty exam. And the safe harbor language essentially informs the healthcare provider, please don't give us any GINA or genetic information. Do not give us any family medical history information. So this is a quick run through of what's gone on with the ADA in the last year or so. And I hope you'll find it useful, and I hope it will keep you from having any claims or difficulties under this statute.
Super. Thank you so much, Margaret. Very insightful. Just to remind everyone, if they do have any questions pertaining to this presentation, they can email them to marketing@axionhealth.com, and we will make sure that we present those to Margaret and then get answers back to you as soon as we can. So once again, thank you for joining us on this edition of Axion Health's Clinical and Professional webinar series, and I hope you all have a good day. Thanks again.